Major breaking news. Cook County has just filed their opposition to the cert petition in the Viramontes case, dealing with whether or not AR-15s and semi-automatic rifles can be banned under the Second Amendment. We're going to cover the details of that brief in 1 second. But before I get there, don't forget, folks, Friday afternoon, it's coming up real fast. I got a super special treat for all of you. So make sure you click on and you watch the Halloween special of the Four Boxes Diner this Friday afternoon. That's going to be tomorrow. I think you're going to really like it. But in the meantime, stay tuned. We're going to break down this brief in the Viramontes case when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so you know there's that major semi-automatic rifle ban case, AR-15 ban case called Viramontes in front of the U.S. Supreme Court now. It's up on a petition for cert. We're waiting to see whether or not the Supreme Court takes this case. I think they're a few weeks away from conferencing the case, so we don't know what's going to happen this term. Will they take an AR-15 ban case or not? Only time will tell. With that said, the Cook County, Illinois District Attorney's Office, the county attorney's office, just filed their opposition, arguing that the U.S. Supreme Court should deny cert in this case. So the question, of course, is going to be whether or not the Supreme Court is going to decide to take an AR-15 semi-automatic rifle ban case this term. And if they do so, I think the proper vehicle is to take the Viramontes case. It's clearly a layup in favor of the Second Amendment. The only question is, will the Supreme Court exercise the political capital, expend the political capital from their perspective, not mine, but from their perspective, to take an AR-15 case? But in the meantime, Cook County did put up an effort here to try to persuade the Supreme Court to not take the Viramontes case this term. And they didn't do a particularly great job, but, you know, they're on the wrong side of the law, on the wrong side of the facts here, on the wrong side of history. But with that said, let's just talk about the arguments that Cook County did make. And again, if the Supreme Court denies cert in Viramontes, it will almost certainly have nothing to do with any of the arguments made by Cook County's lawyers in this case. It will have everything to do with the Supreme Court making a decision about how they want to sequence some of this changes in American jurisprudence when it comes to the Second Amendment, because, again, they have a very big, long-term, multi-decade perspective, which is how they approach cases at the U.S. Supreme Court level, because the decisions they make reverberate out for years, if not generations into the future, and they make different decisions with a different criteria as opposed to just winning, losing kind of issues, if that makes sense. So with that said, Cook County argues different things to try to get the Supreme Court not to grant cert. And it's not a particularly persuasive brief. Even the lawyers probably didn't think it was a particularly persuasive brief when they wrote it. And the best evidence of this is the first several pages of this brief. And I'll put a link to it down below to the Cook County brief. The first several pages are really just listing examples of mass shootings occurring with semi-automatic rifles. Supreme Court is not stupid. They understand this. Just keep in mind when they decided the Heller case in 2008, which said that semi-automatic handguns and all handguns are protected arms under the Second Amendment and cannot be banned by the District of Columbia in the Heller case. That was in 2008. And we know what happened in 2007, which is the terrible Virginia Tech shooting where dozens of people were shot and many people were killed using semi-automatic handguns and magazines that held more than 10 rounds. And notwithstanding the 2007 mass shootings at Virginia Tech, which was not only aware of in the news, but also litigated in front of the Heller, because there were amicus briefs talking about this mass shooting from 2007 in the 2008 Heller decision, or in the 2008 Heller case. The Supreme Court was well aware that crazy people misuse firearms to do terrible things. But with that said, the Heller case came out in favor of the Second Amendment, pointing out that we do not measure and narrow the scope of constitutional rights because some nut jobs misuse firearms or misuse the First Amendment or misuse things. That is simply not how the Supreme Court does it. So the fact that the Cook County attorneys here would spend pages listing mass shootings in light of the history I just described between the Virginia Tech shooting and the Heller decision it just goes to show you they didn't have a lot to say, because if you had something to say, you would not want to waste pages on just listing what everyone understands, which is nut jobs, psychopathic wackadoodles, misuse firearms, and all sorts of other things in American life. That is not exactly news to the United States Supreme Court's justices. Nevertheless, that's exactly where Cook County tried to start off with these sorts of appeals to emotion and these kinds of focusing on the misuse of firearms, but the Supreme Court has rejected those arguments over and over and over again, and will certainly do so again in this kind of case. But then Cook County moves on and tries to argue that there's no circuit split, which is true, sort of. And what I mean by this is that, one of the reasons why the Supreme Court often takes a case is if there's a split in authority among the different circuits. So if the Fifth Circuit down in Texas and the Ninth Circuit in California, in let's say, dealing with a particular constitutional question or a particular statutory question involving federal law, if they have a disagreement about what the law means or how that law should apply, there is a circuit split where some aspects of America live under one interpretation of the law and other areas of America live under a different interpretation of the law, and that creates a circuit split. And the classic way to solve the circuit split is for the United States Supreme Court to grant cert in one of those cases and to resolve the circuit split one way or another, so the entirety of the country lives under that one interpretation of the law, of the First Amendment, of the Second Amendment, whatever it happens to be. So here, Cook County is saying there is no circuit split. And that is a really big deal, because the Supreme Court should not grant cert in this case because there's no circuit split. But here's the thing. As we've talked about before, and again, the Supreme Court justices are extremely smart. They're very smart. You may disagree with some of the stuff they do, but they're very smart. And they understand that the reason why there's no circuit split on whether or not AR-15 or semi-automatic rifle bans are constitutional under the Second Amendment is why. They understand that the only jurisdictions that hear cases involving this question are jurisdictions that are chock full of anti-gun, Democratic-appointed judges, blessed by people like Chuck Schumer. So you're never going to get, or it's very rare to get, any kind of a pro-Second Amendment panel in New York City, because the judges that sit on the Second Circuit had to be blessed by the Democrat senators, Chuck Schumer and Kirsten Gillibrand, right? Same with California. The sitting senators in the U.S. government, the senators are indeed Democrats. So again, the point is the same deep blue jurisdictions that passed the AR-15 bans are the same deep blue jurisdictions that from which you derive these anti-gun left-wing judges. They all swim in the same water, if you will. And you never get an AR-15 ban in Texas, so the Fifth Circuit Court of Appeals never has to rule and strike down an AR-15 ban. Same with the 11th Circuit Court of Appeals out of Florida. You're not going to get an AR-15 semi-automatic rifle ban out of Florida, so there's never going to be an opportunity for the U.S. Court of Appeals for the 11th Circuit, let's say, to knock it out. So you're never going to have a circuit split, because the only circuits that are going to have an opportunity to address the AR-15 semi-automatic rifle ban are the same jurisdictions that are chock full of anti-gun left-wing Democrat politicians and judges appointed by those same sorts of politicians. So that's why there will not be a circuit split. But with that said, there are extremely powerful dissents by powerful, prestigious, well-respected courts of appeals judges, whether it be Judge Walker in the D.C. Court of Appeals, whether it be Judge Richardson there on the U.S. Court of Appeals for the Fourth Circuit, whether it be Judge Brennan, Michael Brennan there in the Seventh Circuit, whether it be the dissent from, let's say, Judge Van Dyke out there in the Ninth Circuit dealing with like a magazine ban. So you have powerful dissents in support of the Second Amendment. So even though you don't have a circuit split, it's clear that there is a split of authority among prominent federal judges on this. And of course, the ultimate Court of Appeal decision was the dissent in Heller 2 in 2011 by none other than now Supreme Court Justice Brett Kavanaugh, who at the time when he wrote the dissent in Heller that said that the D.C. Semi-automatic rifle ban, the AR-15 ban, needed to be struck down under the Second Amendment and under Heller. That was written by then Judge Brett Kavanaugh, 2011 in Heller 2. I can assure you that Justice Brett Kavanaugh has not forgotten exactly what I just said. Okay, enough said on that. So the next thing that happens here is that yet again, the Cook County is trying to argue, and listen carefully, folks, they're trying to smuggle into the text of the Constitution, into the Second Amendment, the in common use test. As you know, the way you apply the Heller standard in an arms ban case or an arms regulation case is you start with the plain text of the Second Amendment, and then you take a look at the Heller decision. The Heller decision defines every single term in the Second Amendment that's relevant for these purposes, including what is an arm. Specifically, the Heller decision says that an arm is something that can be used offensively and defensively. And then the Supreme Court goes on to say that because the text of the Second Amendment refers to the right of the people to keep, which means to possess, and the right to bear, which means to carry, the only arms that are protected as a matter of a textual matter, are those bearable arms, which means arms that can be carried. So what happens here is Cook County argues, specifically they write, quote, contrary to Veramonte's telling, Heller did not consider all weapons to be arms within the protection of the Second Amendment. Well, that's really true in the sense that it's true that all weapons do not fall within the plain text of the Second Amendment, because those weapons that are not bearable, which means cannot be carried by people, would not be textually armed. So, for example, if you're dealing with a battleship, if you're dealing with a massive ICBM or a missile or things like this, these are things that you cannot carry, and therefore you cannot bear them. And under the Supreme Court's interpretation of the text of the Second Amendment, because it's not something you can bear, it's an arm you cannot bear, it's not a bearable arm, it means textually it's not falls under the protection of the text. Nevertheless, the real standard we're talking about here, when you're talking about AR-15s and you're talking about semi-automatic rifles, these are obviously bearable arms. They're rifles. Everyone on the planet Earth can basically carry one of these. They're bearable arms. And as a consequence, when you ban a rifle, when you ban an AR-15, when you ban a semi-automatic rifle, and by the way, even if you ban a machine gun, the plain text is implicated because those are all bearable arms, which means you then shift the burden to the government to show, and this is very important, you shift the burden to the government to show that there's a historical tradition of firearms regulation that would justify the ban. And here's the kicker. The in common use test derives from the historical tradition of firearms regulation component of the text first, then historical tradition component second. And the reason why we know this is what Justice Scalia literally said in Heller, where he describes the historical tradition of regulating dangerous and unusual weapons. Specifically, Justice Scalia, when he wrote the Heller decision, wrote the following, and here's the weird part. I'm going to quote the Cook County brief trying to argue that Justice Scalia would agree that you can ban AR-15s. Here's what they say on page 36 of their brief. Justice Scalia's next sentence supports this reading. He writes, quote, we think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Now, what Cook County is trying to do is they're trying to smuggle that language and say it's part of the text, but that is simply wrong. Because again, the Heller court defined what is an arm. It points out that it's a bearable arm. It's protected. Presumptively, the burden shifts to the government. And then again, there's a historical tradition, which Scalia literally says, historical tradition of prohibiting the carrying of dangerous and unusual weapons. So again, if you're dealing with a weapon that is in common use by Americans for lawful purposes, it cannot be a dangerous and unusual weapon because it cannot be unusual. And beyond that, and this is the key, this often gets lost, because the burden is on the government at the historical tradition level of the text first, historical tradition analysis second, because the burden of proof is on the government at the historical tradition part of the Bruin methodology, which is really just a cookie cutter version or easier to understand version of the Heller methodology. The burden of proof is on the government to show that a weapon is not in common use. Do you hear what I just said? The burden of proof is not on the Second Amendment rights claimant to prove something's in common use. The burden is on the government to show something is not in common use, because the in common use test is derived from the historical tradition part of the methodology. And at that part of the methodology, the burden is on the government. Now, the reason why this is extremely important to defeating Cook County's argument, which is very readily easy to do, is that Cook County spends a tremendous amount of time in this brief, and I can assure you the Supreme Court doesn't care, but they make a tremendous big argument about how they think that the Second Amendment rights claimants here The plaintiffs in the case, Mr. Veramontes and his lawyers, failed to create a proper record. This goes back to what I keep telling you folks, and you're well aware of this, is that the anti-gun movement in America wants to force the Second Amendment rights claimants to build all these crazy records and spend all this money, and develop all these experts, and put on all this material evidence, and so on and so on. But none of it's necessary. And you don't have to believe Mark Smith at the Four Boxes Diner. You simply have to look at what the Supreme Court has done in other Second Amendment cases. Specifically, if you look at the Heller case in 2008, if you look at the McDonald case in 2010, if you look at the Catano case in 2016, if you look at the Rahimi case in, the Bruin case in 2022, or the Rahimi case in 2024. See what I'm saying? Whatever it is, guess what? Guess what? None of those cases involved a trial. None of those cases involved expert reports. None of those cases involved testimony or testifying experts or anything of the like. Not at all. And yet here, the entire argument, or one of the main arguments by Cook County, is that there was not a full-blown trial record that established that these arms are in common use, that these arms are protected under the Second Amendment, and the Second Amendment rights claimants correctly say, we don't need to do it. It's not our problem. The Supreme Court has never required that in the past. And anyway, the burden of proof to show that an arm is not in common use is on you, Cook County, because you're the government. And these are bearable arms you've just banned. So you have to show their weapons are not in common use, which you simply cannot do because these weapons are ubiquitous. There are tens of millions of these AR-15s in America. There are tens of millions of semi-automatic rifles in America. So obviously they're in common use and thus cannot be banned. And the only way that Cook County and the other anti-gunners are trying to get around this is by trying to argue that the in common use test and the other tests, they have other theories about why this is the case, relying on Bevis and whatnot, but they're trying to say these other tests all get elevated to the plain text of the Second Amendment, which I've told you that was going to happen. And the reason why they want to elevate these tests to the plain text level is because the burden of proof at the plain text level is on the Second Amendment rights claimants. It's on the Second Amendment plaintiffs. It's not yet shifted to the government. And once these matters get shifted to the government where the burden of proof is on the government is dead meat. They cannot win these cases because there's simply no way with a straight face you can argue that AR-15s and semi-automatic rifles, for example, are not in common use by Americans, where there are tens of millions of them out there. And remember, all that has to be done is these things have to be owned, because if you own these things, you are keeping, which means to possess, and or carrying them, which means to bear. So the bottom line is simply owning these things is indeed common use. You are using the gun simply by owning it, because the text of the Second Amendment says the right to keep, which means to possess, and the right to bear, which means to carry. So if you own these things, you possess these things, and you carry these things, you're obviously satisfying the plain text of the Second Amendment, and the government cannot show they're not in common use because they're ubiquitous. They are in common use. Okay, folks, so there you have it. We'll see what happens with the Supreme Court, what they do with this. There will still be a reply brief coming, I believe, from the Second Amendment petitioners here, and I'll cover that when it comes on in. But in the meantime, thanks for tuning in. I appreciate your support. Don't forget to follow me over on X at 4 Boxes Diner, and to subscribe here to YouTube and to Rumble. And I look forward to talking to all you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.